Let's talk about state complaint procedures. The drafters of the Individuals with Disabilities Education Act anticipated that disputes would inevitably arise between parents and the schools in which their children were being educated. Filing a state complaint is one of the ways for parents and schools to resolve these disputes. Filing a state complaint with the state administrative agency is a long established alternative to filing due process for resolving educational disputes. The state complaint system offers parents a less costly and more efficient mechanism for resolving certain kinds of disputes than impartial due process hearings. Here in California, the state complaint process is administered by the California Department of Education. So, who may file a state complaint? Unlike due process complaints, which may be filed only by local educational agencies or parents of students with disabilities, a state complaint may be filed by any organization or any individual, even one from another state. In addition, the proper subjects of the complaint are much different than in due process hearings. So, a formal request to the California Department of Education to investigate allegations in which the complainant believes the public agency, generally the student school district, has violated special education law or regulation or federal or state. Complaints may concern one child or student or a group of students. Examples of when a person might file a written state complaint might include where the complainant believes that the school district or charter school is not providing the services included in the child's IEP. Or maybe a copy of the child's IEP was requested by the complainant and the district or the charter school did not provide such a copy. So they're more black and white types of allegations rather than due process complaints, which are more about the appropriateness of IEPs. So a state complaint must include certain things when you file it. It needs to include a statement that a public agency has violated a requirement of IDEA. It must include the facts on which the statement is based. It must include the signature and contact information for the complainant. And if alleging violations with respect to a specific child, the name and address of the residence of the child, the name that the school that the child is attending, and in the case of a homeless child or youth, available contact information for the child and the name of the school the child is attending. Also, you must include a description of the nature of the problem of the child, including facts relating to the problem and any proposed resolutions to the problem to the extent such resolutions are known and what's available to the party at the time that the complaint is filed. The California Department of Education does have a model complaint form available for use on its website, and there's a link to the form here. But the complaint may also be written as a letter. It doesn't have to be filed on a particular form. The party filing the complaint must provide a copy of the complaint to the local educational agency, so it could be a school district or a charter school, whichever public agency serving the child at the time that it files the complaint with the California Department of Education. The IDEA requires that a state complaint allege a violation that occurred not more than 1 year prior to the date that the complainant filed the complaint. So there's a 1 year statute of limitations for state compliance complaints. However, states may extend this time requirement and they may accept complaints for violations that have occurred more than 1 year prior to the date that the complaint is received. So it's really up to the discretion of the California Department of Education. The Office of Special Education Programs has stated that it would be inconsistent with the IDEA for a state agency to require that the individual filing a state complaint to bear the burden of proof in that proceeding. So once a state Department of Education receives the parent's complaint, then it's totally up to that state agency to gather the evidence and make an independent determination. So again, this is different than due process complaints, where the individual who files the due process complaint has the burden of proof. Here, once it's filed, that burden shifts to the state agency to gather whatever evidence is necessary. So, in terms of the state complaint procedures, first, the California Department of Education will review the complaint to make sure that it has all of the required information that's included in the complaint, and then they assign an investigator. Then the California Department of Education will send what's called a notification letter indicating that what allegations are going to be investigated. Then the California Department of Education will send the local educational agency what's called a request for information and a written response within a prescribed time period, usually around 2 weeks. So within that request for information, typically it's going to be the opportunity for the local educational agency to indicate whether or not it believes that there's been any violation of IDEA and provide all kinds of documents that have been requested by the state. There is a word of warning here that any refusal by the public agency to cooperate with the California Department of Education and provide the investigator access to any records or other information related to the allegations in the complaint, or otherwise fail or refuse to cooperate in that investigation or in any way obstruct the investigation, could result in a finding based on the evidence that's been collected so far, and that a violation has occurred, and it may result in imposing a remedy in favor of the complainant. So it really behooves any school agency that has had a complaint filed against it to really cooperate and provide whatever documentation is being requested by the CDE investigator. Then the investigator will gather facts about the allegations through communications with both parties, trying to really confirm and get clarity on what the allegations are. Communication to obtain clarification and additional information and facts from both the complainant and the school involved, specific to the allegations. They will review any documents that have been submitted by both parties. Sometimes they may arrange for interviews to occur with relevant school staff if necessary, and they may even conduct a site visit if CDE decides that that's necessary in order to make a determination on the allegations. So, although not a comprehensive list, these are the kinds of things of the stuff that might be reviewed by the Department of Education. They might be looking for things like service logs to show that services were implemented as they said they were supposed to, and schedules of services. They might ask for copies of any assessment reports that have been conducted, including assessment plans and school calendars to make sure that timelines were met. They could ask for copies of IEP documents and IEP meeting notices or meeting minutes and notes of those IEP meetings. They could ask for copies of any prior written notices that have been sent from the school to the parent, talking about any actions that have been taken by the school. They may also ask for copies of any settlement agreements if there's been an allegation that a previous settlement agreement between the parties has not been complied with. So what happens if the school has bad facts? What if they get a complaint and they realize, yeah, you know what, we didn't do the thing that we were supposed to do? So generally, the recommendation is to still make sure that when you're responding to the Department of Education, that you include all relevant information regarding any corrective actions that have already taken place. So, for example, if the allegation is that the school failed to provide records in a timely manner, maybe once you get the complaint, you send the records to the parent, and you indicate that to CDE that you've already complied with the request to provide the records, even though they may not have been provided in a timely manner. So this way they have all the information. You may still have a finding of noncompliance, but all of that information is going to be considered in determining whether or not any further corrective action is warranted. And they also might consider alternatives to resolving the complaint. So we'll talk about what those alternatives to resolving the complaint in a minute. But let's say the investigation goes forward. What happens then at the end of the investigation? So the California Department of Education is required to issue a written decision regarding the complaint within 60 days of receiving the complaint. And so they're pretty strict on those timelines. And so sometimes schools have been successful at getting a little more time to submit documentation that may be requested as part of the investigation. But the Department of Education is under its own timeline, that 60-day timeline, to have a written decision issued. And so any delay in providing the information that they need as part of the investigation could delay the ultimate findings, which CDE needs to stick to that 60-day time frame. So the decision must address each allegation in the complaint, and it must include findings of facts and conclusions and the reason for the department's final decision. The Department of Education must also have procedures in place for the effective implementation of the final decision, including technical assistance activities, negotiations, and corrective actions to achieve compliance. So a lot of times these decisions will say, here are the things that we want to see. We want to see evidence that you have actually complied with our corrective action, and there may be timelines associated with needing to submit that evidence back to the Department of Education. The only time that CDE can extend this 60-day timeline is if exceptional circumstances exist with respect to a particular complaint, or if the parent or whoever filed the complaint and the LEA have agreed to extend the timeline in order to engage in mediation or some sort of alternative dispute resolution if that option is available. However, the following types of things would not be considered an exceptional circumstance that would warrant an extension of a 60-day timeline: staff shortages or school breaks, or the use of mediation or alternative dispute resolution without agreement to extend those timelines. So both parties would need to agree to extend those timelines. So the California Department of Education is required to make sure that all relevant information is reviewed as part of that investigation, and that an independent determination is made as to whether or not the public agency has violated a requirement of IDEA with respect to the complaint. So the kinds of remedies that might be available whenever the Department of Education has found a failure to provide appropriate services: CDE is required to address the failure to provide appropriate services, including corrective action appropriate to address the needs of the child, such as compensatory services or monetary reimbursement, and any appropriate future provision of services for all children with disabilities. CDE has very broad flexibility to determine what types of remedies are appropriate in order to resolve the complaint, if they have found that the LEA has failed to provide appropriate services. So again, this can include things like monetary reimbursement or even compensatory education services. Possible corrective actions may include also, and these are very typical kinds of things that we see in CDE decisions. It may require the school to convene an IEP team meeting. It may require the school to provide staff training in areas of noncompliance, or even to provide a memo to your staff reminding them of certain procedural requirements. And then again, to turn around and submit evidence of those trainings, for example, the sign-in sheets of who attended those trainings, that sort of thing. They also could order compensatory education services and timelines by when those compensatory education services need to be provided to the student. And they can also order that the school review and revise certain policies and procedures if they feel that that is necessary. So once that decision is issued by the Department of Education, either party has the opportunity to request reconsideration of the decision if they're not happy with the outcome. So this request for consideration must be submitted no later than 30 calendar days from the date of the investigation report. And the reasons for reconsideration could be that the findings are insufficient to reach a conclusion of law, that the findings of fact were not supported by substantial evidence, that the conclusions were inconsistent with the law, or that the corrective actions fail to provide a proper remedy. So CDE will assign an investigator again in this reconsideration process to review the request and any information that's been submitted. They'll gather additional information if that's necessary, and they can either modify the report issued by CDE, or they can deny the request, and they have another 60 days to do so from the time that that request for reconsideration is submitted. It's important to note that CDE is not going to consider information that was not previously submitted unless it was somehow not available to the party during CDE's investigation and couldn't have become known to the party during that time with due diligence. So that really, they don't want to look at any new information because they will ask, well, why didn't you provide this to us earlier? Did you not know that it existed? And only then will they consider that kind of information. So if there's a state complaint that's also the subject of a due process hearing complaint, or if the state complaint contains issues which are part of a due process hearing, the law says that the Department of Education must set aside any part of that complaint being addressed in the hearing until the hearing is concluded. And if an issue raised in a state complaint has previously been decided in a due process hearing involving the same parties, the due process hearing is going to be binding on that issue. It's also important to note that CDE will review any due process hearing decisions that may result from a due process case, and they may actually issue corrective action in addition to whatever OAH has ordered. Also, in terms of any binding precedent of these CDE reports and of investigation, they're not considered binding precedent on any Office of Administrative Hearing decisions. At most, the report might be considered evidence that OAH considers in making a decision on a due process case. And they do also have jurisdiction over enforcing settlement agreements. So where there may have been a settlement agreement of a due process claim previously, the Office of Administrative Hearings only has jurisdiction over those claims alleging a denial of FAPE as a result of a breach of a settlement agreement. But CDE compliance complaint procedures may be used for allegations of just a mere breach of the settlement agreement. So it's only if there's a denial of FAPE that arose because of the breach of the settlement agreement that the Office of Administrative Hearings will take a look at that. Also, although IDEA authorizes independent hearing officers to hear claims related to disciplinary changes of placement or manifestation determination reviews, CDE also has authority to resolve those kinds of issues under its state complaint procedures. And so this means that a parent who disagrees with a disciplinary change in placement or the outcome of a manifestation determination review may seek relief through the state complaint process instead of requesting a due process hearing if they so choose to do that. There also are some alternatives for resolving a state complaint to be aware of. One is a mediation process, which is available to resolve a state complaint. The mediation process is voluntary, so both sides would need to agree to participate. It is considered confidential, so anything that's said during that mediation process couldn't be used against one another if later on there is an investigation. If you agree to participate in mediation, then the parties may agree to extend that timeline for the complaint, and that investigation would pause while the parties participate in mediation. The mediations for state complaints are conducted by the Office of Administrative Hearings, which is the same agency that does all of the due process hearing mediations. And it would be held via video conference, just like mediations held under due process cases. There is a request for scheduling a mediation of a state complaint, and there is a form that is available on the Department of Education's website, and we've put a link to that form here in the materials for you. There's also an opportunity called what's called a local resolution of the complaint. And so this isn't necessarily a formal mediation type process. Again, this is an opportunity for the parties to get together and voluntarily decide to resolve the complaint. So again, this could lead to a withdrawal of the complaint, rendering further state investigation unnecessary. So again, using my example we used earlier, where maybe a complaint's been filed that a student's special education records weren't provided in a timely manner. The school may agree with the parent to provide all of the records, and maybe they would agree to do some updated training of their staff in terms of providing records in a timely manner to parents. That may be a way to resolve the complaint very, very simply. And all the complainant would need to do is submit a signed letter to the Department of Education withdrawing their complaint. And in those situations, until they get that signed letter withdrawing the complaint, that timeline to responding to any requests for information from the local educational agency would continue. So the investigation doesn't stop until that letter is submitted, indicating that the complainant is withdrawing the complaint. So for additional information on special education complaint processes, please take a look at the California Department of Education's webpage at the link below. And just one more thing, although disputes between parents and schools may occur, state and federal agencies expect that both will make every effort to work collaboratively in the best interest of students to resolve disagreements at the earliest possible point of disagreement. And so successful resolution at the local level or through mediation may lead to withdrawal of the complaint, which would render further state investigation unnecessary. Thank you.